Is Oscar Pistorius' 6-year prison sentence for murder a travesty of justice? Why did Judge Masipa choose not to hand down a minimum sentence of 15 years? Was it possible for Judge Masipa to preside over a case in which she was found to have erred? Are any of the parties involved in the Pistorius case likely to appeal the sentence? What time is it? It's question time. Welcome to the show. My name is Mpho Tsedu. Kindly note that Question Time had invited, of course, Mr. Zwelinzi Mavavi and musician Mzwake Mbuli for a discussion on the latest developments at the public broadcaster. The debate was somewhat postponed, and we apologize for erring on that note. However, today, earlier today, Judge Thokozile Masipa sentenced Oscar Pistorius to 6 years for the murder of Reeva Steenkamp at the North Gauteng High Court in Pretoria. The case attracted a lot of interest from within the country and abroad. This after the Supreme Court of Appeal replaced Pistorius' culpable homicide conviction with murder in December last year. The verdict has raised eyebrows, though, since a murder sentence carries a minimum sentence of 15 years. We are live, and therefore you can call us and air your views. The numbers to dial 0891104210. Our Twitter handle at Question Time 24. My guest today, or usual, Advocate Romeo Ntambeleni and Latima Hapa is our legal expert. Latima Hapa from Mahapa Attorneys. Before we continue, though, let's have a look at what Judge Thokozile Masipa had to say about Oscar Pistorius' sentencing.
I have considered the evidence in this matter, the submissions and argument by counsel, as well as the relevant case law and other authorities. Although a custodial sentence is the proper sentence, I am of the view that a long term of imprisonment will not serve justice in this matter. The accused has already served a sentence of 12 months imprisonment. He is a first offender, and considering the facts of this matter, he is not likely to re-offend. In the result, the sentence that I impose on the accused for the murder dolus eventualis of the deceased, that is Reeva Steenkamp, is 6 years imprisonment.
Okay, thank you very much there, gentlemen and lady. Thank you very much for joining us. Now, here you are, 6 years. People are saying, oh, no, not 6 years. Was it possible to get anything more?
I was surprised by the number of years that were now set out by the court. But be that as it may, the judge indicated that she has used her own discretion in deciding after looking at compelling and substantial circumstances of the case. And that's what made her to arrive at the decision that she has arrived at. But like I said, surprised, yes, I was, because for culpable homicide, he was sentenced to 5 years, and the least that I expected was at least 10 years for murder. But she said she has used her discretion, and if you I've listened carefully to her judgment. She tried to create a background as to the reasons why she has arrived at the decision that she has arrived at.
Did she err?
I think what is a bit challenging is the fact that our law obviously caters for the discretion. That's why she said she used her own discretion. And indeed, I concur with what the my learned colleague here has just said. To say, he was surprised. I was surprised as well. However, because of what the law caters for, using her own discretion, That's what it is.
Does it matter what we think as the public?
Indeed, it does matter, because it's one of the key elements that obviously in making a decision one has to consider. Public interest as well. It's one of the key issues that, you know, as a judge or a magistrate, when you make a decision, you really have to look into as well, even though it's not the only requirement.
So, but it doesn't matter that a lot of people are saying, no, they should have given him 25 years or, you know, things like those. She doesn't necessarily have to listen to what we are saying, but she has to consider.
She has to consider, indeed. However, because in this case, there are two parties involved, obviously Oscar and the state. So it allows, you know, any of the parties to actually escalate the matter, you know, by appealing. So if the judge has erred, any party that is not happy about the judgment can actually take it forth.
Now, what would be the next level?
Obviously, what my learned colleague indicated is the appeal. Just to add more on what my learned colleague alluded to earlier, for me, she was leaning more into mitigations, you know, of sentence than aggravation, you know, for me. And she said, you know, in her judgment that, I know that, you know, there's a huge public interest in this matter, but I'm not going to listen to you. But what my learned colleague is saying is very much it's of critical importance, because, you know, the Criminal Law Amendment Act was born out of what my learned colleague has indicated, to say, you know, there was an outcry that, you know, for certain type of offences, there must be a minimum sentence. And when you deviate from a minimum sentence, there must be substantial and compelling circumstances. But where we have a problem, those substantial and compelling circumstances, you know, have not been defined. I can look and say, you know, this is Mpo, he has got this, you know, the following challenges, and I'm going to say that there are substantial and compelling circumstances. And like my learned colleague has said, the discretion rests on the judge. She said, I know that the public, there was an outcry. I know that there were certain perceptions in the public that were, you know, said about this accused person, which there was no evidence which was laid before, you know, that was brought before the court. So based on that, I'm not going to entertain you know, those views. My job is to apply my own discretion, having looked at the case, having weighed the two issues that were, you know, before court, and then I'll make a decision on that. And you know, that was the issue.
Okay, Mwatu, you are in Midrand.
No, Mzanda.
Lenda.
Urin.
Haron Busange.
Short one, I'm gonna. You know what, I like to understand maybe those legal experts that they could advise and give guidance to me as a layperson. Pistorius was convicted of, initially was convicted of culpable homicide.
Yes. Whereby
the sentencing was 5 years.
Yes.
Fine. Then now, he has been convicted of a murder with the very same judge had only had 1 year on trial. So now, they were talking about exceptional and compelling circumstances that if a person of murder, if the person committed a crime of murder, the minimum sentence that the person could face is 15 years, unless if there is this may make you to deviate from the judgment. I need to understand the discretion of the judge or a magistrate. What guides the discretion of a magistrate when they have to deviate from the minimum sentence?
Okay.
Yes.
All right. Okay. You're giving it to your learned colleague there. Yes.
Yes. The thing is, our law doesn't determine exactly, you know, or cap what the discretion, to what extent can you really, you know, base your discretion on. And I think it's one of the issues that it needs to be looked into, and so that we are clear and really cap it. It must have limits, so that, you know, justice can be done.
So basically, this is a very powerful woman.
Indeed, when you're a judge, you are a power. You're clothed with the judicial authority. That's why she said, I hear the noises that are being made, but I'm not going to entertain them. Yeah. I'm going to apply my own discretion. And unfortunately, to your caller, I can't answer what the discretion is. It differs from one person to another. I might exercise discretion saying that Mpo is from Venda, I'm from Venda, and when I'm judging, I must be lenient. It's a discretion that I use. Nobody can take that discretion away from me. That's why she said, at least maybe that discretion must be defined now. It must be determined.
We're going to take a quick break. When we return, we'll continue our discussion. The numbers to dial is 089 110 4210.
There is a sign for perfectionism. There's a sign for goosebumps. Something that symbolizes more performance. A sign for a special mindset. There is a sign for everything we stand for. Audi Sport, born on the track. Built for the road. Join the League of Performance.
Welcome back. You're still watching Question Time. I guess Advocate Romeo Ntambeleni and Latima Hapa, legal expert from Hapa Tennis. Tarzan, you are in Mpumalanga.
Yes, I'm in Mpumalanga, my man.
Yes, welcome.
Yes, I just want to indicate my concern to the viewers that the Judge Masipa disappointed us, taking back that previously they had no opportunity to have female judges. So she is supposed to prove herself that she can. So unfortunately, she has disappointed us. Pretoria is supposed to get a harsher sentence, especially she killed a woman, and the judge is a woman. She's supposed to show that really we mean business that women must be protected. But unfortunately, she did not do that. Unfortunately, I'm so sorry. So she is not capable, so to say.
Okay, Tazan, thank you very much. Does it matter really who the judge is?
No, it doesn't matter who the judge is. I'm of the opinion that as long as one is capable, whether male or female, and anyone can err, whether being a male judge or a female judge, because it would be very unfair to even start saying because of an error of one person, then women are not capable. That would not be a true reflection of what the situation is supposed to be. So hence, I'm quite sure there are other women who are sharing the same view in the legal profession as myself in relation to what has transpired today.
Now, where can either the state or Pistorius go?
Pistorius, we now know that he's not going to take the matter any further. It favors him to get that the 6 years. He will not tamper with the 6 years. And then the option is open only for the state to appeal, because it sets a bad precedent. If you leave it as it is, it means that people can cite this case as an example when a similar case of a similar facts arise. They say, let's use this as an example.
As a case law.
Yeah, as a case law, and then it's precedent, and it will be tried law if it's not appealed. But for Pretorius, it's victory, for him. 6 years, because the challenge is if he appeals. And then the appeal court says, no, you were not supposed to be even given 6 years. You are supposed to be given 15 years.
Okay.
It won't be good for him.
Butani, you are in Limpopo.
Thank you very much, Mpo, for taking my call.
You're welcome.
I want to reiterate my previous time when you had your guest from Kotsi Mampuru, the commissioner there.
Yes.
I want to reiterate again.
Yes.
Let us not be sensitive to the Oscar case. Judge Masipa Thokozile has interpreted and has applied the South African law as it is. Remember, she has got the discretion as the court seated there. She has got the discretion whether to deviate from the minimum prescribed act or not. So she used her discretion, and I think as South Africans, we must be proud and applaud Judge Thokozile Masipa in applying the South African law. Let us not criticize Masipa individually. Let us look at Masipa and the interpretation of the law. From a legal perspective, I think Masipa has done absolutely well under the circumstances that she was faced with, and the evidence spoke to her. She could not have diverted from the evidence and consumed the public opinion in convicting Oscar Pistorius.
Thank you very much, Butani, for that contribution. Now, we know that this Oscar has already served 12 months or so. Is it taken into consideration in this sentence?
Yes. The judge has actually indicated that she has taken that into consideration.
So what does it mean? Does it mean that he already gets a little quota out?
Yes, he might end up serving 2 years to 3.
Is that fair, advocate?
Yeah, I think when the issue of fairness is relative, it's neither here nor there. It depends on from where you are actually sitting. But we have given you our analysis to say, we're a bit surprised because, as legal, trained people, we know that there are cases and we follow those case law.
Yes.
There was a case that was submitted by the NEL for the state versus Malchus. He submitted actually a whole lot of authorities relating to what remorse is and compelling and substantial circumstances and what should guide the court in arriving at the conclusion. And the judge said, I've looked at those cases, and then I've looked at both submitted by Mr. Hernel for the state and Beruru, but I'm not going to consider them. I'm going to use my own discretion. We come back to the very same thing. I'm going to use my own discretion given the facts that we have on the table. The challenge that we are saying is that this is a precedent, and then it can be used by any other person to argue in a similar case, and it becomes a problem.
Matodzi in Rustenburg.
Yes, how are you?
I'm well, thanks for the call.
Not a problem, sir.
Yes.
I'm not sure if you have read Josh Orwell's book called The Animal Farm.
Yes.
It says all animals are equal, but there are those who are more equal than others.
Yes.
So I suppose in this Oscar Pistorius case, somehow, even if the judge used her own discretion, I still believe that 6 years for murder is too little. And furthermore, I would like to know, or actually find out one day, what the discretion was actually used by Judge Masipa. I would really like to know what actually discretion was used there.
Okay.
But nevertheless, I must say, I'm so disappointed on the judgment.
So you think it's an Animal Farm situation?
I believe so.
Okay. Well, I read the book when I was still at Masidibu High there in Seshego. And yeah, all animals are equal, but some are more equal than others. But tell me, was it necessary for us to be put through what we were subjected to? Oscar walking in his studs and all that, him crying and all that. Was it necessary? Is this what you lawyers do to try and perhaps compel the judge to have mercy on your clients?
I wouldn't say it was necessary or not. I obviously don't know the reasoning behind what has transpired.
Yes.
And obviously for one to put evidence before court, they need to do what is necessary, what they regard as necessary. So I wouldn't say it was or not. Probably it was.
Ezekiel, you are in Gauteng.
Good evening.
Welcome to the show.
Thank you very much. Just a quick point.
Yes.
I think judge is also considering the fact that Oscar is disabled. We don't have to run away from that. Now, we can also prove this in the future with a similar case that can happen. The other judge who will be taking that case will give a very, very different sentence with regard to this one. So she considered the fact that he is disabled. So I heard him several times when she was speaking, even in previous court. So that's what I wanted to say, Mpo.
Okay, thank you very much. Rumi, I'm saying, really, what was it meant for television? Was it meant for sympathy? Was it meant to mitigate?
I think I agree with my learned colleague. When you are standing and you are arguing a case on behalf of your client, you throw the kitchen sink, literally. Anything that you actually have in your disposal, you must be able to use it to try whether you're swaying the judge in your favor or against. It depends. So it's a challenge. But let me speak to this issue of disability. Throughout the case, we must not shy away from the truth. It was stated that this man had options, that he could have explored, and we could be, talking a different situation altogether. But despite that's what the Supreme Court of Appeal, having the knowledge of what he has, he reconciled himself with shooting behind the door that was closed, and not only one shot but 4 shots. That's why the Supreme Court of Appeal said we are now changing this. And then we spoke about dolus eventualis,
yes,
and then dolus directus is neither here nor there. But they said with the knowledge that you are having, with the training that you have on firearms, the advantage that you have, you still reconcile yourself and then shot 4 shots without actually knowing whether there was a baboon behind the door, whether there was a human being. You did not care. You didn't care less. And that argument holds water. To say that it doesn't matter whether you're disabled or not. You have options. You have got full mental capacity, and he was tested. That is why it was decided that he was fit to stand trial. There was an argument, which was a very good argument, which was brought by the state, by Hirinel. He said the man failed to take the court into his confidence, but he does a television interview trying to explain to the whole world what happened into the day. But you have an opportunity before a judge to actually come clean, but you said, no, I'm not going to do that. I choose to do a television interview.
But the television interview had not been broadcast yet, so we didn't know the content.
But we knew what he was going to be talking about. He was going to be speaking about what actually transpired on the day. When it was led in court by the state, there was no objection saying that he was not going to talk about the events of the fateful night. It was not said there.
What would you have done if he was your client?
Maybe even before you get to that level, maybe just to add on what my colleague has just said, that we are talking about somebody who's very trained and somebody who has managed through obviously the sporting code that he was involved in to actually go beyond his disability. So obviously, why do we want to then focus on his disability now, whereas he has managed to go beyond the challenge itself? That's why I'm saying, really, I concur with my learned colleague that we shouldn't shy away from the fact that his disability was actually one of the key issues that was brought into this matter.
So what should we learn as South Africans out of this case? I'm hoping that this is the end of the Oscar Pistorius.
I'm hoping it's not the end. I'm hoping that an appeal could be put forth by the state.
For what now?
On the basis that if nothing happens, then it's a precedence. That has actually been, said by my learned colleague, to say a lot of people can come and use the same judgment that we had today and utilize it in the similar circumstances.
I also agree with what my learned colleague alluded to say. It shouldn't be the end of the matter, because we are saying that 6 years that was imposed was not a fair sentence. So if the state appeals, it is in the interest of the states to actually follow it up to the last step.
Okay. Let me thank you for the time, my learned colleagues. Question time adjourns.
Thank you very much.
Thank you very much.
That was question time, and have yourself a wonderful time. Goodbye.
There are no permanent enemies or friends in politics.
I agree with Professor Siete fully. Do people still preserve the meaning?
They have no clue what it meant to be black under apartheid.
Acting Police Commissioner Phahlane dropped a bombshell in Parliament this week when he suggested there could be a possible cover-up. What do you think of this story? What kind of problems were those, Vuyo, if I can just get in there quickly?
Every corner or sphere of our lives has become a site of struggle.
Watch Media Monitor with me, Alicia Jali, Sundays at 9 a.m. only on the SABC News Channel.
A time and a place to relax and disconnect from the world as you recharge your mind, body and spirit. The Fordoon Spa in KwaZulu-Natal offers that and more.
We are a spa in Africa, and I was lucky enough to know Elliot Ndlovu, who's a traditional healer. He's both in Inyanga and a spiritual healer. Elliot came to me and he said, you know, John, if you're going to be doing anything, he said, think about me as well. So I did. And Elliot gave us a lot of advice about traditional plants. And we looked at these plants and we saw which of the plants grow well here and which of them could be used in products that we make. So all of our own amenities in the hotel are made from the plants that we grow here.
We do a sort of fair range of treatments, all your normal massage, manis, pedis, all your usual ones. But we also incorporate a few other ones that are more traditional because we do incorporate Elliot Ndlovu, who's our traditional healer, into the spa treatments. So we kind of put our own little twist on a few things. For instance, our massages, instead of using your traditional sweet almond or grapeseed, we use either our artemisia or our wild dacha oil. There's a couple of clients that are a little bit wary, but most of them come around and think it's an enjoyable treatment. And most of them love our wraps and teas and little other extras that we do.
When I studied, when I was trained by my ancestors underwater, that's where all my ancestors told me that's what I must do. That in my future, after becoming a traditional healer, I must grow herbs, I must teach people, I must live ukuthi ngitshala amayeza esintu ngiwasebenzise ngesintshonalanga like propagation, ngiwadayise and ngikama product amatiya nama cosmetic product. Then I studied from there. I was lucky that kwafika uJohn lapesco ethi sibanibani ngoba utshala izinto ukwafika lapha eplazini sinenkinga wenza profit would one day we're going to start a spa and this kind of business. Now I want to start it. Can we be the part of it? Because this is what came to your profit. Ekhaya le ngistarte khona. Mina ngiqala ukusebenza, I started working at home in 1990. I started to have white people there, 80%. Ngifike la about 10 to 15 years ago.